Good morning, Mr. Cripps. Ms. Bonomo.
Good morning, Your Honor.
Morning, Your
Good
Honor.
morning. You here on Ms. Bonomo?
I'm here on Donald Robertson.
Oh, great.
With
I got
Mr.
Mr. Cripps here.
Morning.
And Mr. Robertson. How about that?
Yes, Judge.
You are.
My client should be on Zoom, Your Honor.
He's here.
Call it case number 240-7316 for the state of Michigan versus defendant number 1, Donald Robertson. Defendant is charged in count 1, reckless driving causing death. And then has a habitual offender, second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Sarah Bonomo on behalf of the people, P841189.
And good morning, Your Honor. David Cripps, P34972, appearing on behalf of Donald Robertson. He's joined us by Zoom.
Mr. Robertson, tell us your name for the record. Unmute yourself and tell us your name, sir.
Donald Robertson.
What's your pleasure, Mr. Cripps?
Your Honor, I've received a competency to stand trial report in this matter, both from the Forensic Center and the Independents. I'm prepared to stipulate to the conclusion of the report from the Forensic Center recommending that my client be found competent to stand trial.
Mr. Bonomo?
Your Honor, I've had an opportunity to review the report, and I agree with defense counsel.
All right, court will make a finding that the defendant is competent to stand trial. Are you demanding an exam, Mr. Cripps?
Yes, Your Honor, we're ready to set an exam date.
Okay. How is February 22nd at 9 o'clock?
Works for the people, Your Honor.
Judge, I have a jury trial set that day, but I expect that case to settle before the 22nd. So I believe I can do that date.
Okay. So we'll go with that then. February 22nd at 9 o'clock. File will be continued.
9 o'clock, Your Honor, did you say?
Yes, sir.
Okay,
Yes, sir.
thank you. Thank you.
Thank you, Your Honor.
Sarah, I need a little bit of discovery. Can I call you?
Yes.
All right. Thank you, Your Honor.
Thank you. Have a good day. You're all set, Mr. Robertson.
All right.
Good morning, sir.
Good morning, Judge.
What can we do for you today?
I'm here with the farm program, and then we have one of our guys that's coming before you today. And I'm here as an advocate for him, Eric Charleston.
Yeah, that's set for exam at 10:30.
10:30?
Yes, sir.
Okay, I'm early. All right, I'll be back then. You're familiar with our program, right? Aren't you familiar with our program?
Somewhat, yes, sir.
Okay, good, good. All right, 10:30, I'll be back. Thanks again.
Okay, no problem.
Charleston.
Metals.
Still on the highway from over there. Somebody's taking the highway over here, somebody works. Charleston Metals and Custom.
Good morning. Is that a real design attempt for the contract?
This record is on.
Okay.
Nat 15 claims here. I mean, and
How you doing, man? Ms. Young? Got
Hey, good morning.
it? How you doing today?
Wow,
I hear.
yeah, she's here. Yes.
Lana Destiny Davis. Calling case 2455466, people of the state of Michigan versus Lana Destiny Davis. Defendant is charged in count 1 assault with a dangerous weapon, count 2 assault with a dangerous weapon. And appearances for the record.
Good morning, Your Honor. Shelley Jason.
Good morning, Your Honor. Sean Godwin, P74500 for Tawana Davis. Who stands before you? Please say your name.
Tawana Davis.
There's a date and time set for preliminary examination. Are you ready to proceed?
Your Honor, I'm not able to proceed at this time. The complaining witnesses, Mr. Louis Smith and Ms. Michelle Thompson, they were notified to they were time for the exam. We are not permitted.
Your Honor, I make a motion to dismiss.
So, Ms. Davis, are you fresh? Super Bowl party? Like you
No.
still dressed up for?
No.
Before we dismiss this matter without touching, dismissal ordinance without.
Right here. I got you right here.
Oh, sorry. Sorry. Yeah. So running around.
You go in the hall for it.
know, listen, guys.
Yeah.
Like I was just texting somebody about that.
Yeah.
Compilations.
Okay. Okay.
Morning, Judge. Mr. Sullivan. Back again.
Back again. Hopefully, we can get a little farther into this. Good day.
Not bad, not bad.
Your name there first.
Judge.
That's fine, that's fine. Are you ready, Mr. Sullivan?
I believe so. She's coming.
Does she have witnesses?
She does.
Okay.
Thank you.
Bernard Lovell Meadows. Calling case 2455459, people of the state of Michigan versus Bernard Lovell Meadows. Defendant is charged in count 1 aggravated assault. Appearances for the record, please.
Good morning, Judge. Neighborhood Better Service. My name is Sullivan, E84261. Here on behalf of Bernard Meadows, who's present. Mr. Meadows, can you state your name for the record?
There's a date and time set for preliminary examination. Are you ready to proceed?
Mayor, I would ask for those things. I would ask either if we could begin testimony of the complainant who is present, or if we could adjourn to the. So the reason that this is a case where the inevitable something that is based on the EPO. So the complainant, she just arrived, she has an EPO, so she sends out her part so she can bring that. However, for the proof of service, the only document that shows the proof of service is the lead. And I would have to have an officer to testify. There is not an officer present. I contacted the officer to ask that officer to bring a copy of the video and the proof of service. Officer is here. I cannot go forward with this case without those documents. So again, I do have a complaint.
Judge, may I, yes, provide maybe some more information? My investigator, if the board is interested, my investigator is on her way. She went to the office that has the court office that has records of these PPOs. She has received where there would be a proof of service in that file, the document is blank. So there's no proof of service according to the records that we've subpoenaed from the clerk's office. Obviously, she can't testify to the lack of service, but I did subpoena those records and my investigators. I'd ask that Your Honor dismiss the case, given the prosecution for the economy, the elements of the offense.
Just on that issue, I do have a certified copy of the insurance actions for the and it does indicate that there was no issue that was granted. However, there is no entry which says on here that it was served, but that is not necessarily uncommon. It just means that however it was served was not properly filed with the circuit court, and it wasn't entered into just the register of action for this year. It doesn't necessarily mean that it doesn't exist. And
Or that he wasn't served.
because if I'm reading it, I can't necessarily believe that
The time declined is declined to hold the matter in part. Said for a very brief return to take this week. To be a very tight window, because I recognize it in a business person. But I also recognize that I eventually have a complaining witness who's done everything that she believes she's supposed to do in terms of getting personal protection. And due to no fault of her own, it would be different than something that she did or didn't do because this happened. So I'm going to hear from the plaintiff witness today, who said they over probably took Wednesday, which the personal protection. Let's proceed. So,
There is some people called Kenneth now.
ma'am, please step forward, give your name and the spelling of your name to the young lady seated there. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat. The witness box right next to me. Just pull that door open. Have a seat. When you sit down, speak into that microphone that will be to your left. In fact, you take the base of that and place it in your lap so you can speak directly into it. You pick up the base and set it in your lap. Yes, sir. Maybe again when you're ready.
Thank you. State your name again for the record. Kenya Knox. All right, Ms. Knox, I'm going to be asking you some questions. If you don't understand something, or if you want me to repeat it, please let me know. All right? Okay. All right, Ms. Knox, do you currently have a PPO against? Yes. And who is that? Bernard Meadows. Okay, how do you know Bernard Meadows? We was in a relationship, and he is the father of my 2-year-old daughter. Okay. When did you get the PPO against? Well, first of all, do you see Mr. Meadows in court with you today? Yes. Could you indicate where he is and what he's wearing today? He's wearing a green shirt and white shirt under. Is sitting to the left of you. Thank you.
The cushion that goes on the microphone stops it, go back to listen again.
I'm not accused of the resident was left with the defendant, the defendant when they're in medical.
So noted.
Thank you. And when did you get this PPO?
It was granted in May of 2023, like May 30th.
There's no just object to the witness testifying as to whether it was granted.
All right, so
I think that would sort of involve the service fee, which is an issue.
that's two different things, whether it's granted and whether it's been served. She testified that it's been granted. But it was never served.
And did you get a copy of your PPO?
Yes, it was emailed to me.
Okay. And where is that copy?
It's still in my email. I did not need to bring that actual this copy of it today. I thought you guys would have it in the system.
Did you read it?
Yes.
And what were the prohibited behaviors that you read in the PPO?
Judge, I would object to best evidence.
Suspend.
All right, and since you got the PPO, have there been any violations of the PPO that you're aware of?
Yes.
Judge, I'm objecting again, I calls for a conclusion.
Well, Your Honor, she indicated that there was a PPO that was granted, she has a copy of it, she read it. She says she knows what the prohibited behaviors are, but she just hasn't stated them. I'm just asking.
Can she email you have your cell phone? Can you access your email from the cell phone?
Yes.
Can you email the PPO or forward it to me?
Okay.
Can you do that now? Kenneth, Kenneth, King, King, at 36 TH District, BISTRICT Court, one word, COURT.org. Kenneth dot between Kenneth King. Kenneth dot King at 36 TH District Court.org. Can you not see this? Mr. Sullivan, would you like a copy of it as well?
Yes, please. My investigator did just bring me copies of a few things, so I may have, but just so we're all looking at the same thing.
Jonathan, print it out.
Okay, thank you. You can get that.
Thank you, George.
May proceed.
Thank you. Thank you again, Your Honor, for assisting with the copy of the video. So at this time, I would move to admit people's exhibit number 1, which is a certified copy of the register of actions for case number 23-105481-PP, Kenneth Knox versus Bernard Meadow. This is a register of actions for the people that we now have in front of us, which does state that there was a PPA that was granted on May 30th of 2023, which is the same date as the PPA that we now have on paper.
Any objection?
No objection for the purposes of the exam.
Admitted?
All right. So I'm going to ask you, again, you read the PPO? Yes. Okay. So you know what the prohibited behaviors are of the PPO, correct? Yes. Okay. So, after you were granted the PPO, were there any times or instances involving Mr. Meadows that were violations of the PPO or unwanted contact? Yes. Okay, could you indicate what those were?
Just for the record, I'm objecting to part of that question. I understand the prosecution can ask whether there's unwanted contact, but again, part of it also.
I'll sustain. that objection.
Well, since you had the PPO, have you had any contact? Or has Mr. Meadows had any contact with you? Yes. And what was that contact?
Multiple different times that he's contacted me, but recently it was on Instagram. He was sending threatening messages through direct message. He was going to kill me. I went to my daughter's school and blow my head off. We even sent a video of them holding a gun, saying that you better stop playing with me. And that just really alarmed me and made me very, very, very afraid.
Okay. It made you worried and afraid. Yes. Okay. Afraid of what?
Of him or what he might, what he's going to do, or what he might do, or what type of mind state that he's in.
Okay. So the instances that you just described, was this all just one day, or were there multiple instances on multiple days?
It was 2 days. The first day was January 24th around like 9:30 p.m. and then again on January 26th around 8:30 in the morning.
So you said that, first of all, what is there any sort of custody of parenting time arrangement between the two of you regarding your child?
Yes, I currently have full custody of our daughter, Jackson, in my house. And he is supposed to supervise visits through, a facility that he is supposed to, set up. He set appointments for, but he has not done that.
So you said you received, the contact was Instagram messages, is that correct?
Correct.
Okay. So so you're saying he sent a message to your Instagram, is that correct?
Yes,
And how did you know that it was him?
because it's his Instagram profile. It has his pictures on it. And the Instagram page that he was direct messaging me on is Instagram. It's my daughter's Instagram page that I actually run.
Judge, I'm objecting to the speculation here as to whether this is actually Bernard Meadows.
Goes to his weight, that's in this.
Judge, I don't think that this witness can authenticate that these messages are coming from my client.
That goes to his weight, not his disability. His weight, coach, she believes that she articulated why she believes that it's coming from him based on her familiarity with the defendant and his Instagram post, as well as one that is designated for her daughter that she.
Judge, just my objection is that I think a violation of a PPO is an objective fact, not a subjective fact. And so it's not, necessary. It may or may not be relevant whether she believes that a message is coming from Bernard Meadows, but Your Honor has to find probable cause for Your Honor to believe that a message is coming from Bernard Meadows. And so we have to authenticate that. On what basis, how is it she's able to authenticate that message is coming from Bernard Meadows?
Again, the objection goes as to what weight coach should trip, not his disability.
Have you ever received a message on Instagram from Mr. Meadows?
Yes.
Okay. And when you did receive that message, was it from, was it the same Instagram that you had received a message from before?
Yes.
Okay. And you said that the messages were to your daughter, or your daughter's account, is that right?
Correct.
Okay, and so was that the same Instagram that you had seen or received messages from before from Bernard Meadows?
Yes.
Okay. And again, if you could state what the content of those messages were.
The messages were, he was going to funeral. My family was going to cry at my funeral because he believed that I had a man around my daughter, and he was upset about that. He said he multiple messages saying he was going to let the clip loose on me, and the last thing that I was going to hear was "boom, bitch," and that he was going to come up to my daughter's school and blow my head off. He also sent a video of himself holding the gun, stating that you niggas better stop playing with
Judge,
me.
I'm again objecting to that.
Sustained.
Do you have a copy of that video?
Yes, I do.
And where is that?
It's in my phone. So I submitted everything, to the police. But I do still have the video. I do still have all the screenshots of the messages.
And where's your phone?
In my purse.
I went home. All right, first witness.
Yes.
Judge, for sake of ease here, I'll stipulate to the witness's account of the messages. I'm objecting to her testimony of the video.
She's going to show the video, right?
Yes. Your Honor, could defense counsel and I approach the witness?
Sure.
As neither one of us has a video. We both do have the text messages that the complainant has testified to as that.
Straight both of those.
Ms. Knox, you just showed defense counsel tonight, a video on your phone, correct?
Yes,
And is that the video that you just testified to?
yes.
And again, what does that video show?
Judge, again, I'm objecting to us getting into this. This could have been sent to discovery weeks ago. I think it's improper for us to be adding evidence just the very morning of, in the middle of an exam. It compromises Mr. Meadows' ability to access adequate representation. Typically, I would do investigation when I receive discovery. I would have an opportunity to review this with Mr. Meadows, and we short circuit all of that by just introducing additional evidence, video evidence, in the middle of an exam. So I think that the prosecution can meet their burden as to violations of a PPO, and Your Honor has allowing us to come back on Wednesday to argue the issue of whether there's actual notice of this PPO. But I don't think at this point, in balance of the prosecution's burden to prove probable cause, they're able to do that on the strength of the messages. I don't think that they need to get into this video, and I think that it does prejudice my client that I've not had an opportunity to review it with him, and I've not had an opportunity to do any investigation as to the video.
Well, there's a couple of things we can do in that regard. You can let the people continue with their direct exam of this witness. Give you an opportunity to review the video with your client when you come back, because we're coming back Wednesday anyway. Come back Wednesday, and then you can do your cross-exam Wednesday. That's not enough time for you. Come back a week from Wednesday.
Wednesday should be sufficient, Judge. I suppose that I would just maintain my objection that I'd like to have an opportunity to review the video with my client before.
That's what I'm giving you. That's why I'm putting it to Wednesday.
Right, and I appreciate that, Judge. But I maintain my objection if the prosecution is going to be able to get into this on direct before I've had an opportunity to discuss.
That's why we're going to do your cross-exam Wednesday today. So you'll have an opportunity to go over the video with your client prior to cross-examination.
But not prior to direct examination.
What can you do during direct examination? It's not your witness. People are asking questions.
I make objections, Judge.
You can still make objections. You had an opportunity to review the video yourself, right?
Just this morning, just moments ago.
Right. Same as Ms. Grant. Proceed.
Thank you. All right. The video that you just showed defense counsel that, either that time stamp on your phone?
Yes.
It was,
Yeah, timestamp on my phone is timestamp with direct messaging.
okay, and what is that on your phone? What is the date on your phone?
1 moment.
Thank you.
Timestamp January 24th, 9:27 p.m.
And is that when you received it?
I received it on January 24th. I would have to look at the actual Instagram direct message to see what time it's actually sent.
Was it the same date? Even if it was a different time?
No, it's the same date. Yeah.
And that's 2024.
Yes.
Okay. Okay. And as to. Any other questions?
Yes.
You recognize what I just handed you?
Yes.
And what did I hand you?
The messages that was sent to the Instagram page from Firehouse.
Okay. And, if you could look through those for a moment. Just let me know when you're ready.
I'm ready now.
And are those messages that you just looked over, are those some of the messages that you received that you just testified about?
Yes.
And those are copies of what was sent to you on Instagram by Mr. Meadows, is that correct?
Yes.
Now, based on that, I would ask that the complainant read those messages, based on her identification, I ask that this witness read those messages into the record.
Any objections to something? No objection. Admit.
If you could please read those messages into the record.
Bitch, I'll wait at Varsity School for you to come and get her and blow your fucking head off behind the shit you did. Come to bitch ass outside so we can get this over with. I'm gonna catch you sooner or later, ho. You're gonna come out for something. I hope you call whatever bitch ass nigga you had around my child to, so I can kill his dumb ass in front of you before I do the same thing to your stupid ass. Bitch, all you about to learn a valuable lesson from this shit you did and allowed to happen to my daughter. They're gonna cry at your funeral, ho. And I hope and pray you think I'm playing. I'm about to find out where dudes stay at too. I let you steal, cheat, lie, and put me and my child in harm's way. And you alienated me from my daughter. So now I promise y'all won't even see me coming. You have never even apologized for all the evil and cowardly shit you did. You are nothing more than a lying, thieving, cheating asshole. This one is the same as one of them.
Okay.
So I should. You and your family are cowards. Sooner or later, I'll see you, and it'll be too late by then. Bitch, tell him my mom ain't gonna do shit, ho.
And, what you just read, was that on one message or were those individual messages?
Individual messages.
Okay, how many of them did you receive?
Eight.
And what date or dates did you receive?
Well, the first ones that I read came on actually January 26th.
Okay.
Of what year?
2024. Actually, I believe all of these came from January 26th. Yeah, all these came from January 26th, 2024.
And when did you say you received the video?
That was January 24th.
All right. There are no further questions at this time.
Thank you, Judge.
Ms. Knox, the messages that you read referenced some harm to your daughter, correct?
Yeah.
And that's harm to a daughter that you and Mr. Meadows share, correct?
Correct.
Vassity Meadows is your daughter.
Yes.
Mr. Meadows here is responding to concern that Vassity is in trouble,
No.
that she's been harmed.
No. He's making things up because he is upset that I moved out, and he is upset that I will not give him half of her disability money. So he's constantly trying to say she's been put in harm's way, and she hasn't. We've already talked about this in court during custody, and the Judge Mary Kelly wasn't wrong with that.
We don't need to testify to what Judge Mary Beth Kelly's opinion is, but it's accurate to say that there was an allegation that Vassity was harmed. Is that correct? That there was an allegation?
He's trying to make an allegation that she was harmed because he believes that I had her around another man. But he cannot control who I have around my child because we are not together anymore and I have full custody of her. Just like if he was to have visits with her, I can't tell him who he can and cannot have in his home or anything like that. So he's trying to make things up so he can say, this is why I'm writing you these messages, or this is why I'm doing this. My daughter's been harmed, but nothing has happened to his daughter. She's perfectly fine.
So your testimony is that when Mr. Meadows makes this allegation that he that he's making up streets.
Yes.
So there's no video that you sent him of this other man with Vassity?
No. There's no video that I sent him ever of Vassity with anyone. He's seen a video of me posting a video of my daughter on her Instagram page. He heard people in the background and assumed that I was like on a date or something and just started going crazy sending these messages.
So you are posting to Vassity's Instagram account?
Right.
And he's also posting to Vassity's Instagram account?
No. He is writing me on Vassity's Instagram account. He hasn't like posted anything from her account. That's what you're saying. Like he doesn't have access to her account. That's what you're asking.
So you're posting as Vassity. Is that what your testimony is?
Well, I am posting pictures of Vassity on an Instagram page that I run.
Under her name?
Correct.
And has that account communicated with what you allege to be Mr. Meadows' account?
Did you say that again?
Have you, under either your name or Vassity's name, so either?
Yes, it has, yes. It has been communication to him from that page. Obviously, I've had that page when we were together, so yes, it's been messages to him from that Instagram page before.
Any messages after May 2023?
Yeah, yes, it was.
So you continue to message Mr. Meadows after you had the personal protection order?
I wouldn't say I continued, but at different times when he had said different things, I had responded back to them, yes.
Okay, so I'll ask the question again. You did communicate with Mr. Meadows after the personal protection order was served.
Yes,
And you even went to his house.
I did.
You went to his house on Thanksgiving.
No, I did not go to his house on Thanksgiving. I was not at his home on Thanksgiving.
Yeah. Can I ask a question?
Sure.
Yes, it's B as in Victor, ASSIDY, last name Meadows, MEADOWS.
So it was not Mr. Meadows' house on Thanksgiving, but it was his sister's house on Thanksgiving, correct?
I did. I took my daughter over to his sister's house so she could see her grandmother. Bernard Meadows was not there.
Your testimony is that Mr. Meadows was not at his sister's house on Thanksgiving?
Correct. He was not there when I was there.
Understood. Is it also your testimony that Mr. Meadows was not there when you went to his sister's house on Christmas?
When I dropped her off there, I don't know. I don't believe he was there, but when I went and picked her up, he was there. I did not go outside. I did not go inside the home. His sister brought my daughter out to my car and he tried to walk up to my car as well, but I got in the car and left.
Okay. So you weren't sure whether or not he was there when you went?
I know, I'm not sure.
You didn't do anything to check whether he was there?
I did not.
Okay, so you just went to his sister's house despite having the personal protection order against him?
Yes, because my daughter was going to spend time with her family on Christmas, which is her grandmother and her aunt. And they are aware as well of the protection order, so they normally don't invite me or for me to bring her there when he is around.
Ms. Knox, when was it that the custody dispute was settled?
November 7th, or between November 7th and 9th of 2023.
That was after you had this personal protection order granted.
Yes,
Fair to say that the personal protection order was helpful to you in gaining custody?
I'm sorry.
It's fair to say that the personal protection order was helpful to you in gaining custody?
Your Honor, I object to this question that calls for speculation. Now, the citizen doesn't know if that helps or not. She's not the judge who made the decision.
Thank you, Judge. You brought the personal protection order to the custody dispute.
No, they already knew about it because it was in the system. I didn't really say anything.
Okay, so it was discussed during the custody dispute?
They said something about it. The judge did say something about it, but if anything, with the custody battle, Bernard Meadows' own actions is the reason why I was granted custody.
And those are actions which you cited in the PPO.
Those were actions that he displayed in court during those two court dates that we had during custody. It's all of you people. Granted me custody.
In your petition for the personal protection order, you cite a conflict that you and Mr. Meadows had in April of 2023, correct?
Yes, April and May.
In April, that's Vasty's birthday, right?
Yes.
And she celebrated her birthday in 2023 at Chuck E. Cheese, correct?
Yes.
And Mr. Meadows, picked Vassity up from the Chuck E. Cheese and brought her home, correct?
No, he took her. She came with me. We had a disagreement during her birthday celebration. He snatched her out of Chuck E. Cheese and took her home with him. It was not, it was never talked about that she was going home. He was upset because he wants, again, half of her social security disability money, and I would not give it to him. So he snatched her out of Chuck E. Cheese and left with her. We called the police, but they didn't get there in enough time to be able to stop him. And I didn't want to go outside to try to get her because he was already upset and just out of control. I didn't want to escalate it like anymore, so that's why I called the police in the first place.
Are you done? I don't want to interrupt. My next question, just following on your testimony here, that you didn't want to go outside, is that your testimony?
Yes, when he took Ashley out of Chuck E. Cheese, he put her in the car. He didn't have a car seat, but somehow he locked her like in the car. He was driving her in the car.
My question, you didn't want to go outside.
Yes, I did not want to.
My next question, you did not want to escalate that.
Right. I did not want to escalate the matter with him. He was already.
So yes or no question?
Yes.
But you went to his house, correct?
When?
That very day in April.
I only went to his house because my sister went there, and I wanted to make sure that she was okay.
Yes or no question, you went to his house.
I did.
And you also asked his sister to go, or your sister to go to his house.
No.
So that would not be her testimony.
Correct.
Why did she go to his house?
I'm gonna object right now as to this line of questioning. I don't believe that this is relevant. First of all, this is an incident that is before the PPO was even granted, so we're not talking about a violation of the PPO. We're talking about something that happened in a birthday party.
Judge, I'll withdraw the question. You were upset on that day because Mr. Meadows had custody of your child, the child that you shared.
No, I was not upset that he had custody of her at that time. I was upset that he misbehaved the way he did during her party and snatched her out of her party.
But you went to his house to get your daughter, correct?
I went to his house because my sister was there and I wanted to make sure that she was okay. I knew that eventually I would get my daughter from him, but that particular night, I did not. That's not why I went to his house. It had nothing to do with getting my daughter at that time.
Understood.
Have anything else, Mr. Soto? No. Redirect.
Nothing further, Your Honor.
So as it relates to this video, is it still the people's intention to do this meeting?
Yes, Judge.
Then I'm gonna have to order you back on Wednesday.
think Wednesday is good for me, guys. We can do it, perhaps later in the morning. Around 9 o'clock.
Do 11:45.
I'm actually, I work on Wednesday, I work at 11:30. I'm gonna be off tomorrow and I'm gonna be off Thursday and Friday.
I'm on vacation Thursday and Friday. There's can't do Thursday and Friday. Good time.
Which, like, day next week, and
We have parties. Okay, after sidebar discussion, we make a determination that we're not going to use that today, okay? Thank you, Ms. As for you guys, we'll pick up Wednesday at 11:45 for their case. You see if the defendant has any witnesses. I'll be continuing, thank you.
Sir.
What happened to Mr. Godwin? Ms. Castell, do we have witnesses on your case?
I'm sorry, Judge?
Do we have witnesses on your case?
I don't believe so, not the last time that I checked. I'll double check. Sorry, Judge.
11:45. Attorney Klein?
Yes,
Are you ready?
we are, yes.
Brendan Hernandez. You know if they have witnesses on your case now?
I don't believe that we do. I'm not positive, I haven't spoken with the prosecutors.
All right, so are you ready to climb this?
I'm ready to go.
Calling case 2455448, people of the state of Michigan versus Brendan Tyler Mendez. Defendant's charged with count 1 weapons, firearms, discharge to vehicle. Count 2 assault with a dangerous weapon. Count 3 felony firearm. Count 4 weapons, firearms, possession by felon. Count 5 domestic violence. Mrs. Quick.
Good morning, Your Honor, Shelley. Good morning, this is Nikki at 0066. I'm gonna have Mr. Hernandez insert his statement for the record, please.
Brendan Hernandez.
There's the date and time set for preliminary examination. I'm ready to proceed.
Your Honor, I am not able to proceed at this time. The complaining witness is not present. I cannot proceed without this testimony today. You would ask for dismissal.
So order, court will dismiss this matter without prejudice. Need a dismissal order?
Yes, please.
Ms. Castell,
Yes, Your
ready?
Honor. Just 1 second, Judge. I do believe there is a witness here. I just want to have a moment to speak with this.
Ready now, Mr. Castell?
Yes, Your Honor.
Ready now?
She's going to speak with her. Sure.
can't do anything to you in my file back. Ms. Castro,
Yes, Your Honor.
can't do anything to you in my file back.
There's your file.
You ready? Where's my file?
Still like. Your Honor, there are some times that will be dismissed after the strike is just.
Calling case 2455312. People of the state of Michigan versus Eric Lamont Charles. Defendants charged with count 1, weapons, firearms, discharge from vehicle. Count 2, weapons, firearms, possession by felon. Count 3, assault with a dangerous weapon. Count 4, assault with a dangerous weapon. Count 5, felony firearms. Count 6, felony firearms. Count 7 and 8, felony firearms. Count 9, domestic violence, sexual offense. Defendant has a habitual offender sexual offense. Next is the record.
Good morning, Your Honor. Shelley Green to the people, number 60249.
Good morning, Your Honor. Nancy Castle, the Neighborhood Defender Services featured. I'm appearing on behalf of Mr. Eric Charleston, number 805.
What's your name, George?
Very long, Carol.
This date, time, set preliminary examination, Ms. Castro.
Yes, Your Honor. Judge, I did have an opportunity to speak with Mr. Charleston. I explained his rights to a preliminary examination. He does understand that. Judge, if you could just give me 1 second. And at this time, Your Honor, Mr. Charleston will be waiving his right to this exam. There are charges on this information that will be dismissed because the payment witness was not here. And those would be as to count 4 and count 8.
Is that correct, Ms. Barron?
That is correct, Your Honor.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one. You'll be bound over to Wayne County Third Circuit Court as you stay in charge. You understand?
Yes.
You understand the nature and the purpose of a preliminary examination? Yes. You understand if you were to have one, the prosecution would have to establish that the crimes were charged with the exceptions of counts 4 and 8, with the city of Detroit, which probably plausibly believe.
Yes.
Is anyone forcing you to waive your right?
No.
Does anyone promise you anything?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No objection, Your Honor.
Court finds the defendant's waiver is made knowingly and voluntarily freely given the court, therefore bind the defendant over to Lake County Third Circuit Court Criminal Division for the proceedings. His arraignment, only information, date and time would be February 19th, 2024. Sorry, that's President's Day, February 20th, 2024, at 9:00 a.m. Final briefings.
Your Honor, if I may just address that real quick. I believe that the PCC, I did, order, or had the court order a BSU report. Did we obtain a copy of that?
We do, and they recommend no action.
Okay, Your Honor, I do have somebody here that is on behalf of Mr. Charleston, as a part of the program that Mr. Charleston has completed. The report. Thank you.
Your name for the record, sir?
Charles Collier.
Please raise your right hand to count. Swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. What do you have to tell me, Mr. Collier?
Your Honor, Mr. Charleston is part of a program called Family Assistance for Renaissance Men. We help gentlemen to overcome barriers that they have, that they keep them from reuniting with their families.
When was Mr. Charleston enrolled in this program?
This was the last cohort, was in July.
July of last year?
Yeah.
And he completed the program?
Yes.
And so, how has this program helped him in that these charges that he's currently facing allegedly took place on January 3rd of this year?
Yeah, it's out of character, Your Honor, but we're asking the court to consider that he has made an effort. The circumstances that he's under now, are generally from, some issues with the child and his mother or some other.
These are some very serious charges. Discharge of the firearm from the motor vehicle. And to make matters worse, him being in possession of a firearm at a time when he's not eligible to possess or have one at all. Or own one. That's a problem for me.
Yes, I understand that is.
So how do you square that with your program?
Well, there's no excuse for that, and we have difficulties. And I suggest that he was just under some pressure or circumstances that drove him to, revert back to something old.
Your Honor, I think part of the reason why Mr. Collier is here is to also let the judge know that should Mr. Charleston or should the court lower Mr. Charleston's bond, that this program would be able to further assist as he is facing these charges moving forward to circuit court. They would be able to provide assistance if, for example, if there's any housing needs that need to be established for him to be able to.
My primary concern is whether or not he poses a danger to the community, or at least to this complaining witness.
And Your Honor, my understanding is that since the allegations in this case, there's not been any contact from my client or the other, anybody that knows.
He's been in jail.
Correct, and obviously, as we know, people from jail sometimes make phone calls, but there has been no allegations that,
It's not supposed to, it doesn't make any points for that, sorry. Had a prior domestic violence in December 2019. Is that involved in the same kind of witness?
I can look that up.
While she's looking that up, tell me what your program consists of.
It's a mentoring program. We offer family development. We offer workforce development. We do training for construction skills, building, drywall, painting, that type of thing.
So what kind of skills did you get?
Well, his issues were with with custody. Every person that's in the program, they have different needs, but we have 5 areas that we cover that would address whatever that person's needs are. Some need housing, some need help with custody issues, need job training, or mentoring. This case is exceptional, Your Honor, but we have quite a success record with men turning their lives around.
So it would appear, Mr. Charleston, that you're making the program look bad. Graduate, and yet you have these very serious allegations over your head.
Yes, ma'am.
Well-respected program. I know this program.
Yes, ma'am.
I could probably vouch for the success of the program too. Then there's always the exceptions. Sounds like you're the exception. So I have the pretrial services who's done an extensive background check on you and recommended that the court take no action as it relates to your bond. People, what say you?
Your Honor, this one relates to the recommendation. It is a medical program, it's a very good program.
Let me ask this question. How did you end up in the program? Were you referred by a court?
I just joined it myself.
Joined it yourself. How did you hear about it?
I heard it, actually, from a friend.
How long were you in the program?
So, like 6 months.
6 months now.
It's 8 weeks, my phone, sorry.
8 what?
8 weeks.
8 weeks. So that's a big difference from 6 months.
Yeah, I heard it was 6 months, 8 weeks. Yeah.
This drain was the same complaint?
No, I think that's the program. However, she is outside of the answer.
Yes, it was the same thing.
It was the same complaint. Okay, so I don't know if that's better or worse.
Yes.
Because if it's the same complaint, then you most certainly pose the dangers of finding witness. Some lessons have to be learned the hard way. Sir, I appreciate you coming down and giving us your input. At the end of the day, I have to do what is just, I have to do what's safe for the community as well. I'm not comfortable producing this bond in light of the program that you entered into with you, the successful completion of it as well. But it has to be able to exhibit some kind of self-control that hasn't been shown to you. So of course, we'll continue to find.
Thank you for
I saw Ms. Bates around here somewhere. There she is. Hey, Ms. Bates, how are you? Okay. Calling case 2455492, people of the state of Michigan versus Beverly Altisha George. Defendant is charged in count 1, assault with a dangerous weapon. Where's Mr. George? Count 2, domestic violence. Appearances for the record, please.
Good morning, Your Honor. Shelley Grant, number 6024. Good morning, Your Honor. Dates 876080. On behalf of Beverly Jordan. Your Honor, I received a court notice that I am here at the podium alone. I am unsure of Ms. Jordan's whereabouts. I do know that she is on a tether. I have spoken with her multiple times, spoken with her as recently as Friday. The date and time. I just called her roughly about 11:06 this morning and no response. I do know that she switches phones. She has limited funds and she has a government issue on that word. But that's what we're saying.
So she'll probably get picked up today. I'll contact Tether and see if they can swing by and pick her up. But she has failed to appear for purposes of disciplinary examination. Unfortunately for Mr. Jordan, we have to get to point C, point A before we get to point Z. She would have gotten a dismissal, but we have to get her here first. First on the issue of cases, remote bond, set to bond 25,000 cash.
Okay, and if I hear from you, I'll email them for her.
You'll probably hear from us.
Oh.
Swing by, pick her up. Maybe she just needed a ride.
That very well should be
She
in
needed a
your.
ride right to the
Yeah.
county jail.
Thank you.
Thank you. Have a good day. Well, that's what, folks. That concludes the docket for today. Hope to see you tomorrow, same back station, same back time. Thank you. Ryan. Good day, guys. So, who are you guys with again? DPD, are you cadets or are you new officers or what? Or you're students, so you're student cadets? Okay. First day. First day, all right, awesome. You guys be safe out there, okay? All right.
I enjoy your day.
Thank you, you too.
Okay.